as I mentioned earlier, we are going to have a trivia question at one point throughout the webinar. It's fairly straightforward, and once I give you the question, provide your answer through the question pane on the dashboard as we just indicated. The first one to correctly answer will win an MWL book of our choice. It could be the auto subrogation book, it could be workers' compensation, it could be ERISA, it could be coverage, it could be Where's the Beef, the auto book, or the auto collision with the livestock book. But I will say the question twice at some point, and then you can answer with your answer. Now, as I mentioned, in order to satisfy requirements for Texas CE for this webinar, some things have changed. They're making it tougher, and they now require us to be able to prove that you were in attendance if they should request it. So far, they haven't requested it, but if they do, and I can't prove it, then you're not going to get your CE credit. So for those interested in getting Texas CE credit, we will provide a code word sometime during the webinar that you will need to remember. Following the webinar, you are going to receive, everybody's going to receive a survey. There is a place in that survey to put the code word. So feel free to answer all the survey questions, but the code word is MWL, no, wait a second. I'm supposed to provide that. Never mind. I'm going to provide that during the webinar, and that's the way the Texas Department wants it, and that's the way we'll do it. So again, we'll answer questions at the end, and thank you for joining us. Today we have 414 people in attendance, and that includes 8 conference rooms from what I'm told. So I don't know the actual total, but it's great attendance for a state that isn't as heavily trafficked for auto subrogation as some other states might be, like Texas, Florida, California, New York. But it is an interesting state for a number of reasons, and by interesting I mean there are opportunities for us to increase auto subrogation recovery, MedPay, collision, UM, and we'll go through the nuances of those areas of subrogation and hopefully give you some tools with which to improve your subrogation efforts. You may recall that this is now the last installment of an 11-episode webinar series that we've done on auto subrogation. We began nearly 2 years ago with an overview of auto subrogation in all 50 states. It was a 2-hour webinar. It was the view from 35,000 feet for those of you who were in attendance back then, and we covered the entire country from a bird's eye view, especially with regard to strategy and how to subrogate auto claims. In that webinar, we asked for and received hundreds of lists of the top 10 states that people had questions about and needed to brush up and have more information on. Those top 10 states we have already covered. We've had webinars on Texas, Florida, California, New York, Illinois, Louisiana, Michigan, Colorado, New Jersey, and now the last one, Arizona. We certainly can provide information on other states, but these were the top 10, and this concludes that series. You are able to go to our website to watch pre-recorded webinars that we gave live on all of those states, as well as the introductory 2-hour 35,000-foot flyover for all 50 states. Back then, and I think it was February 8th, about 2 years ago, we had over 600 people in attendance, and we gave an overview of auto subrogation from 35,000 feet. We will now descend to 5,000 feet and get into a landing pattern as we look at the state of Arizona. Throughout this series, we've focused and reminded you about something you may already know, but it's good to remind ourselves of it as professionals who have a responsibility to subrogate for auto claims. There are 275 million cars in the United States and 7 million accidents every year. This results in $70 billion in auto bodily injury liability claims, $40 billion in auto collision claims, and 5 to 10 people will die in auto accidents during this webinar. 1 hour. We're going to be done hopefully right around 11. Nearly 100 people will be injured in accidents during this webinar. So in our industry, in the claims industry, in the insurance industry, we focus a lot on large commercial property subrogation and catastrophic work comp cases. But the money, the volume, and therefore the money is in the small files. And to successfully subrogate these small auto files, you have to be smarter and more efficient. Unfortunately, the old adage of the old procedures of sending out a bunch of notice letters and just in a letter saying, you know, we've paid out $4,912 in collision damages. We feel you're at fault. Please send your check to this address. You know, that's a 2 on a scale of 10 in terms of how creative, effective, and dynamic you can be in your subrogation efforts. There's a lot more you can do to turn those files. And this is what we do. Matthiesen, Wickert, and Lehrer represents insurers, over 300 insurers, self-insureds, vendors, claims handling firms around the country for work comp, auto, property, ERISA, fidelity bonds, and we do so throughout North America. And over the last 34 years, I think we've discovered that to be successful, we have to be well educated, and we have to keep continuing education at the forefront of our industry. And to be successful in these small files, you have to be smarter and you have to be clever, and that's what makes subrogation in the auto area so difficult. So the goal of this webinar, the goal of the entire series, and I'm giving a little sermon now in preamble to the Arizona automobile subrogation webinar, because we started off with this sermon, and it's important to remember that smart subrogation is the most effective. We don't want to be the bull in the china shop sending out 37 demand letters that are identical until the case goes stale and there's no recovery potential, but we want to be the subrogation surgeon. And you remember back, all the guys remember the classic movie 300, when King Leonidas and the Greeks chose to make their stand at Thermopylae. This very narrow mountain pass was largely neutralized by 300 of King Leonidas's men, and it neutralized the Persian strong cavalry and enabled the Greeks to inflict massive casualties on a much larger army, more than 20 times its size. Similarly, during the American Revolution, our militia, and I'm reading a history book right now on the Revolution, and you know, our militia found that following the old British tactics of standing in a line and firing in uniform volleys and standing as open targets wasn't as effective as shooting from behind hills and trees and employing guerrilla tactics to turn the strength of the British line into a weakness. And that's the strategy that we have to employ in auto subrogation by choosing battlefields and knowing the terrain. And you're going to learn the terrain in this webinar and in hopefully in the previous 10 webinars. Smaller armies with fewer resources can actually shape the outcome of the battle and the rules of engagement. So as subrogation professionals, we have the same challenge. And how do we turn smaller auto and property and med pay and PIP and no-fault losses into recoveries when the other side knows that we won't step over dollars to pick up dimes and that we're not going to pull the trigger on a $2,200 file? Well, the answer is by making the terrain work for us, by knowing the law better than they do, by leveraging the resources to our that we have available to us to our advantage, and by lots of hard work, because there are no shortcuts in this industry, and that's what makes it it can make it successful to our advantage, and it also gives us a disadvantage when we tend to try and take those shortcuts. As we'll see in this webinar, auto subrogation in all of the states we've discussed sort of bleeds into many areas. Bailment, the economic loss doctrine, the made whole doctrine in states where that applies, the common fund doctrine, because we don't want an insured's attorney where he's pursuing a bodily injury claim to take a portion of our fees, dram shop laws, guest statutes, vehicle operation statutes that deal with operating your car on the road. These are powerful tools that we can use. How to recover for loss of use, rental car issues, proof of damages, repair costs, reimbursement of deductibles, regulations that deal with these things. statutes of limitations. Important that underutilized with almost every client I have is the use of offer of settlement statutes, where you can threaten attorney's fees, costs, interests, and things like that if they don't pay you a reasonable settlement offer. Also utilizing unfair claims settlement practices regulations. You cite these things in a letter and imagine yourself receiving that letter. Well, I could pay this $2,200, or I could face a possible claim for unfair claim settlement practices, or I could be exposed to additional attorney's fees. So these are all really powerful tools that can help you increase dramatically, even double the auto subrogation that you're seeing. Because I just spoke at the CLM conference in Chicago, and I spoke on a subject that, by the way, is going to be our next webinar. Jamie has not given me a date yet, but it'll be within the next month, called the 10 subrogation mistakes that insurance companies keep making. And very few things intimidate me, but sitting in front of a room like I did in Chicago, or I did in Connecticut in front of the ExecuSummit conference, in a hall that was filled with gray-haired insurance executives, many of whom have been doing their trade much longer than I've been doing mine. Here's this whippersnapper lawyer standing up in front of them explaining how they were making mistakes. Well, turning those mistakes into advantages and fixing those mistakes is the true test. So we have a book out called Automobile Insurance Subrogation in all 50 states. It covers all of these subjects globally and in much detail for all 51 jurisdictions. I originally had a slide in this presentation on the book. I had Jamie take it out because I'm not hawking books today. In fact, if you knew how much we made as the author on books like this, our publisher is George Publishers out of New York. You'll know that it isn't worth my time to try and sell the book. It's there mainly as a tool to assist and augment yours and mine, subrogation efforts when we undertake those needs. So this is the end of the sermon now. We have to think like trial lawyers. We have to think creatively. We're in the insurance industry, which traditionally limits liability. We are here to create liability. So let's now talk about how to successfully subrogate in Arizona for automobile claims. Arizona is an anti-subrogation state. What does that mean? It means that Arizona has a public policy that clearly states that you cannot assign a bodily injury cause of action. They won't allow subrogation language in bodily injury claims, and we'll talk more about this, but just remember that Arizona is a little challenging because it is an anti-subrogation state. They have nearly 3.5 million licensed drivers, but 16 to 25% of them are uninsured. Arizona has equitable and legal subrogation, which is good, but MedPay subrogation is not allowed. There's only a limited lien. This is just an overview. Arizona does not have any no-fault, which is good, and I have a lot to say about the failed no-fault experiment and its effect or lack thereof on automobile insurance premiums. UIM subrogation is allowed, but only for not UIM. We'll talk more about that. There's an exception to the anti-subrogation law. Collision subrogation isn't listed here, but that you'll see is also an exception. They have limited application of the made whole doctrine. This is one of Arizona's strengths, is that, well, my insured wasn't made whole, so you don't get to recover your collision damage or your MedPay claim. Not so fast, because Arizona really hasn't developed the made whole doctrine very well, and we'll talk more about that. Unlike 254, I believe, counties in Texas and a lot of counties in California, the state of Arizona has only 15 counties. And overall, Arizona is a reasonably plaintiff-friendly state. And by that, I mean plaintiff versus subrogated carrier. So the plaintiffs win about 60% of the cases statewide, and the plaintiffs have a slight advantage when it comes to going in front of a judge and saying, oh, XYZ insurance company wants to take my claim away via subrogation, please don't let them. Federal court is a little more defendant-friendly than state courts. So overall, the state of Arizona is fairly plaintiff-friendly. But what is interesting, and this isn't on this slide, and this should be remembered. Now we're going to start talking about these tools, these special tips, the advantages, the little widgets that you can take from this webinar and put into practice in subrogating your auto claims. Arizona is the home to the majority of the Navajo Nation in the United States. It's the largest Native American reservation in the United States. It covers 27,500 square miles of the state. It's larger than any of the other 10 smallest states in the United States. Its capital is in Window Rock, Arizona. Tribal law can be used to your advantage. You need some expertise when working in tribal law in states like Utah, New Mexico, and Arizona. But Indian tribes are, as you may know, distinct, independent, sovereign communities. They retain their original natural rights. Although they don't technically possess the full attributes of a sovereignty like, say, the Vatican and Rome, they do remain a separate people with the powers of regulating their internal and social relations. So Native Americans possess the right to make their own laws and to be ruled by them. Why do I mention this? Because with 27,000 square miles in which to have accidents, cars burn up, auto claims, and things of that nature, using tribal law to your advantage will get the other side scratching their head and put you in that driver's seat whereby, oops, there's a claim for unfair claim set or a demand based on unfair claim settlement or offers of settlement or tribal law. Those are the claims that get paid because those are the claims that put the other side outside of their zone of comfort. So tribal judges, there's Arizona tribal courts. They're different than state courts. And they are significantly different. There's tribal judges, and so state courts have jurisdiction over lawsuits between non-Native Americans arising on the reservation. However, jurisdiction over a suit by any party, Native American or non-Native American, against a Native American person, a tribe or a tribal entity, that jurisdiction lies in tribal court. So I mention that because that's one of the distinct characteristics of Arizona. Let's talk about Arizona limits. And we'll be moving quickly through some of this. But Arizona, mandatory bodily injury liability, auto insurance, 15, 30, 10. 15 per person, 30 per occurrence, 10 for property. You've got to have that. By the way, if you don't have that, the book, and we don't go over it in this particular webinar, but the book contains an entire chapter on pulling driver's licenses, how to retain those and renew those suspensions, and how to get money paid through installments in the cases involving those 17 to approaching 20% uninsured Arizonians. So this liability pays for damages to people and property of the victim of an accident for which the insured is responsible, or any driver covered in the policy. Commercial trucking limits, this is also important. If household goods are involved, the limits are 300. If general freight is involved, the limits are 750. If oil transport is involved, there's $1 million, and hazmat, $5 million. So the minimum amount of primary liability insurance is set by the Federal Motor Carrier Safety Administration, and primary liability is often confused with general liability, and there's a big difference. General liability covers you for accidents that happen off the road, but primary liability won't cover you for that. It covers you while you're on the road. So drivers in Arizona can temporarily uninsure their vehicle if the vehicle will be or will not be or hasn't been driven on the roads. And this is important for subrogation professionals to know, but insureds can de-insure their vehicle. They fill out a de-insured certificate on the Arizona DOT website. So that's often a reference point and a resource that we can go to see what their history of insurance is. And then again, in order to provide insurance, all the insured has to do is provide an insurance ID card, a copy of the insurance policy or a binder, or a certificate of self-insurance. Let's look at A little bit more at the liability limits. Interstate motor carriers, if you have 16 or more passengers, have to have $5 million in insurance. 15 or less passengers, $1.5 million. School buses are not covered with this. But 3 commercial endorsements, just to be familiar with in Arizona, that are approved in Arizona, is the MCS 90. This MCS 90 endorsement starts off because of the Federal Motor Carrier Act of 1980, which simply says that each motor carrier, each company that does carrying of goods for others participates in interstate for-hire commerce, has to show proof that they have the financial responsibility required in the minimum set by each state. So this MCS 90 is an easy way for them to show this professional responsibility. And it can be done in either one of 3 ways. They can self-insure, they can provide a surety bond, or they can procure insurance through the standard market. And if they do that, this is where the MCS 90 endorsement comes into play. It's nothing more than a guarantee that there will be some source of funds to pay when you have a motor carrier involved. The BMC 91 filing is a document filed to the Federal Motor Carrier Safety Administration, and it guarantees them that you have enough liability insurance to cover the increased risk of transporting goods or people across state lines. Lastly, there's a Form E filing which certifies that liability insurance complies with the state financial responsibility law, and it's submitted to the departments of the business's home state that regulates trucking insurance. So you can look for those endorsements. Now we're talking about insurance requirements, and in Arizona, uninsured motorist coverage is not mandatory, but it is mandatory to be offered. It has to be offered in no less than the minimum liability limits, and it can be rejected in writing. It has to be rejected on a form approved by the DOT. It can be combined single limits. In Arizona, you do not need to convey the premium in the offer, and it must be extended to all persons covered under the auto policy. You can exclude some family members. So because the number of uninsured drivers in Arizona is estimated to be approaching 20%, it's just important to remember, again, uninsured motorist coverage protects the insured or passengers in the insured's vehicle for bodily injury that the insured or passenger sustain when involving a driver with no liability coverage, and then the UIM or underinsured protects you or the insured when involved with a driver who has, no matter what the limits are, limits insufficient to cover the injuries or damages sustained by the insured or the passengers. So those are some concepts to remember when we're talking about the insurance requirements for Arizona. Here's a typical UIM policy term. We will pay damages which a covered person is legally entitled to recover from the owner or operator of an uninsured vehicle because of bodily injury sustained by a covered person or property damage covered by an accident. Underscoring this, of course, is the fact that it must arise out of the ownership, maintenance, or use of the uninsured vehicle. And I throw this in here because it does come into play in subrogation claims, but there's a 1992 Arizona Court of Appeals decision involving an incident where 2 drivers of vehicles were shooting at each other from moving cars, if you can believe that with today's headlines. And there was a claim made under the UIM policy, and the trial court granted summary judgment in favor of the carrier. There were actually 2 of them, Farmers and Continental in that case. But the Court of Appeals had said that because they held that the plaintiff's injuries did not arise out of the ownership, maintenance, or use of an uninsured vehicle, even though they were driving the vehicles while shooting. So just keep that in mind, that we do have that caveat when dealing with Now we get to MedPay coverage. Again, we're not talking subrogation just yet, but MedPay coverage is, as it is in many states, it's optional. It is a no-fault type of coverage that pays medical bills. It covers the insured while in other vehicles. It's great for physical therapy, chiropractor claims, things that might be excluded by a personal health insurance plan. It's an optional coverage. An additional premium is paid to purchase the coverage. They don't have to offer it. The insurer doesn't have to offer it, but it can be offered pursuant to several different types of insurance. This is something to remember, not only auto and motor vehicle, but premises and homeowners as well. So in the event of an accident, $5,000 is usually the amount advised for MedPay coverage. Trial lawyers will have things on their website saying, don't get any more than $5,000 in MedPay coverage. Why, you ask? Well, you'll find out when we get to the subrogation aspect of MedPay, and we're going to discuss that in just a couple of minutes. So usually you find between $1,000 to $5,000, but you can get any amount, and it covers the driver, the occupant, and even the insured as a pedestrian, depending on the policy language. Collision comprehensive coverage. Okay, we all do this. We do a lot of it, and this is where the money is when you consider volume. And this is why getting these tips and secrets under our belt that help us to more effectively recover the smaller collision claims will help us with our gross subrogation recovery across all claims over a business year. Collision coverage, again, it pays to repair or replace a vehicle after a collision. Doesn't matter of the fault. And it's usually the actual cash value, the market value of the vehicle before and after, or the cost of repairs. And you can also recover for, the insured can recover for loss of use, the cost of rental cars, and we'll talk about subrogating that in a moment. Comprehensive coverage, on the other hand, repairs or replaces vehicles after damage that's caused by non-collision incidents such as theft, fire, vandalism. It also covers the cost of a rental car if it's your fault. Again, actual cash value or the cost of repairs. What's important to remember here is if you think back to when we first started talking about Arizona and we said it was an anti-subrogation state. That means it prevents an insurer from subrogating because, well, the anti-subrogation rule and the policy in Arizona is simply that we're not going to allow subrogation for bodily injuries. We're not going to allow an assignment of a bodily injury claim. But the anti-subrogation rule is also a rule which simply states that we're not going to allow an insurer to subrogate against its own insured. But this does not prevent an insurer from recovering collision damage from an entity that is insured under the liability portion of the insurer's policy. I mention that because Arizona is different in most states in that respect. But it does prevent the carrier from recovering under the collision coverage portion of the policy, of course. So that's just overview of coverage. Now we get into the nitty-gritty of subrogation. Anti-subrogation state means no direct subrogation of MedPay. Key terms here, subrogation. What does that mean? Do not conflate subrogation with reimbursement. Subrogation is you stepping into the shoes of your insured and pursuing a claim against a third-party tortfeasor for an accident which resulted in either MedPay damages or collision damages or what have you. That's subrogation. You are stepping into the shoes of an insured and taking up his or her or its rights under tort law, and through which you can now recover your benefits. There is no subrogation of MedPay in Arizona. It's prevented because it's an anti-subrogation state. However, reimbursement is different. Reimbursement is the ability to recover back your MedPay or other payments from an insured once that insured has effected a recovery against a third-party tortfeasor. And in Arizona, there is a statute. It's section 20-259.01, and sub J provides that the carrier can perfect a lien for recovery of MedPay for any amounts over $5,000. Essentially, there is a threshold that has to be met, a la no fault. But if you have MedPay benefits of over $5,000, you have, and that threshold is met, you have the ability to perfect a lien. A lien must be filed within 60 days of any payment over the $5,000 threshold. If you're at $3,000 and you pay a $2,200 hospital bill, that puts you over the threshold and the clock starts ticking. These things should be diaried. Be careful. Sometimes subrogation professionals aren't aware of when payments are made. And in order to perfect a lien, you have to file a lien. It has to be recorded in the proper county of loss within the state of Arizona. Now, not only does the statute require you to file the lien, but it has to be filed correctly. It must name all the parties of interest with a copy mailed to each one of them. Later on, if you're reimbursed, again, not subrogated, but reimbursed your MedPay, and you are allowed to be reimbursed for any amounts over $5,000, you get a lien release, and that has to be recorded within 30 days of the settlement, or there could be problems. And it's applicable to any third-party recovery. It can be against the tortfeasor. It can be against the product manufacturer. So look carefully at that statute and keep these things in mind. In Arizona, you've got to diary these dates. When I talk about the amounts over $5,000, an example I give is, okay, if the carrier pays $25,000 in MedPay because they have extended MedPay coverage, you can recover $20,000. $5,000 you give up. That's what the state of Arizona has determined to be their public policy. In addition, when you assert your lien and you file your lien and you do everything correctly, and the plaintiff comes to you and says, hey, I need you to waive your lien because my client won't settle the third-party case if he has to pay you back $20,000. Well, you know, the terminator approach to subrogation that I preach so forcefully with other areas and in other states, you just have to be a little bit careful that the statute itself requires you, the MedPay carrier, to compromise the lien in a, quote, fair and equitable manner. What does that mean? Nobody knows. There is no bad faith simply because you don't compromise it in a fair and equitable manner, but it does allow the court to step in. There's a number of cases that discuss auto MedPay in Arizona. But, you know, in terms of handling MedPay subrogation, a couple of tips that I think should be followed are, once that 5K threshold is met, and that's when the bells and whistles ought to go off, or you know it's going to be met. If you know, if your reserves are X and it's above 5,000, you know it's going to be above the threshold, it's time to put on your subrogation hat. Once you know that to be the case, or have a strong indication that it's the case, the earlier you do the following, the better. You should get statements. You are now putting on your trial lawyer's hat and you want to prove up third-party liability. Get your photographs. Put the insured on notice of your reimbursement rights and your intent to follow through under 225901 under Arizona law. Indicate a desire to assist the insured's attorney, and put that in writing if you can. We'll talk more about why that's important later. Encourage the insured to pursue a claim if he has a claim, because, well, duh, if the insured doesn't pursue it, you're not going to have anything against which your lien will be applicable. So in those instances in which you have somebody going, meh, not quite sure that I want to pursue this, I might, you know, I've got $25,000 in medical, I'm back to work, I'm just, thank God I'm you know, healthy and I recovered. You might want to work out some sort of we do this, a joint prosecution agreement with them. We can put them in touch with an attorney. Would you like an attorney who can talk to you about pursuing your claim and getting you some additional money? These can be effective in most states, but in Arizona, it's indispensable if the insured is not going to pursue it. So those are some things that you can do. Follow the statute to the letter. And I'll tell you that when MedPay Sub is involved, it may be a small amount. Get subrogation counsel involved. This is the time to preserve your subrogation rights. And as much as we'd like to do it all ourselves, most of us don't have time in the claims world. And I see that because I see the bad results. I see the statutes that aren't complied with. I see the lack of investigation. And $20,000 may not seem like a big claim, but it is a big claim. And when you multiply that times the volume that we see, it's important that we do that. Furthermore, we have a duty to subrogate. Why do I say that? Because subrogation in Arizona has a statutory purpose. 20-263 says that under sub A, no insurer shall increase the motor vehicle insurance premium of an insured as the result of an accident not caused or significantly contributed to by the actions of the insured. Whoa. Any insurer which increases the premium as a result of the accident involvement shall notify the insured of the reason for such increase. We all know how sensitive individuals are to their premiums being raised. People try not to report claims. They're afraid their premiums will go up or they'll get canceled. Arizona puts a little backbone in that issue and says that essentially you can't increase premiums if the accident wasn't caused by the insured. So in many cases, it really behooves you to prove that your insured is not at fault. And if there's an issue as to whether or not your insured is at fault, there is subrogation potential, and there's subrogation opportunity, and actually even a duty. So uninsured motorist subrogation, I thought I'd start with the statute. 225901 sub I and K reads that insurers that make payments for damages to insureds for uninsured coverage may subrogate and sue for reimbursement in the name of the insured against any uninsured motorist responsible for the damages. Unfortunately, that does not provide UIM carriers with subrogation potential. And sub K provides that any common law prohibition against assignments of causes of action, i.e. the anti-subrogation public policy rules in Arizona, are abrogated. They're not applicable to the extent provided in subsection I above. So they allow subrogation even though it's an anti-subrogation state. Now again, subrogation is allowed. UIM subrogation is not allowed. Anti-subrogation prohibition doesn't apply. Collision property subrogation is allowed for collision. And there's a case that you can cite because I've had a lot of folks cite, well, we're an anti-subrogation state, you can't do it. You can do it. And you can include damages such as the cost of repair, residual diminution in fair market value, and loss of use. Diminution in value, essentially you get the car repaired, looks brand new, but the car is worth $400 less than it was prior to the accident. And in first-party claims, if that's paid, you can subrogate for third-party loss of that diminution in market value. Loss of use, reasonable rental value for the time period is also recoverable. And you can, generally that's the period of time during which a person is without the use of his vehicle. And there was a very interesting case, I don't think I have it here, involving somebody who was without his car for several hundred days and was able to recover for the loss of use for that entire time period. Now, the main-hole doctrine is something that's a throwdown. It's trial lawyers learn this in first year of law school, and it sticks with them their entire life. But it isn't as applicable and pertinent in many cases as they might think it is. In Arizona in particular, I just want to say that this is not discussed in Arizona jurisprudence with regard to auto subrogation. The Ninth Circuit has a main-hole case applicable to health insurance. And again, we said that statute requires insurer to compromise MedPay liens in a fair and equitable manner, but that's not the same thing as the made-whole doctrine. So when you get this, well, we're not made whole, reply with, please provide me with a case that shows that the made-whole doctrine applies with regard to auto subrogation or MedPay subrogation. There is no such case. And generally, when you do that, you get, at a minimum, a lot more negotiation room. Now, the common fund doctrine, this is the issue about you've got a subrogation lien or you get your reimbursement and the attorney wants to take a big chunk of it for his quote-unquote attorney's fees. Essentially, Arizona does have a basic common fund law established. It says that the person who employs attorneys for the preservation of a common fund may be entitled to have their attorney's fees paid out of that sum. But Arizona has not addressed the obligation of an auto carrier to pay its insured's attorney's fees for a recovery of a subrogation or reimbursement claim. Subrogation in the case of collision, reimbursement in the case of MedPay, say. And this makes sense, seeing as Arizona actually prohibits such subrogation. But the common fund doctrine is recognized in general. It's just not, once again, discussed in the context of auto subrogation. There again, give me a case that says that the common fund doctrine applies and you can take a fee out of our auto subrogation interest. There isn't one. It's applied in other contexts, Medicare, health insurance, and equitable subrogation, but not auto subrogation. This is a common question we get: what happens if you have an insured who goes out and quickly settles with the tortfeasor with knowledge of the subrogation interest? This is why it's important, and this is why it's important. Remember, we talked about the tips for MedPay Subro. If you even have an inkling that you're going to go over the $5,000 threshold, obviously you have to have more than $5,000 in MedPay. If you only have a $5,000 policy, there's no subrogation or reimbursement. But if you're over $5,000, you have that lien right under the statute. This is why it's important. You put everyone on notice, especially the tortfeasor, especially any defendant, because an insured who settles with a tortfeasor who has knowledge of subrogation can still pursue the tortfeasor. What does that mean? I don't care, liability carrier, if you've already settled and you have a nice notarized release in your hand. It's not going to be effective as to me because I put you on notice prior to your settling. So putting people on notice early pays off. The policy, most policies prohibit post-loss actions of the insured that jeopardizes subrogation, but not pre-loss. If a settlement is prior to payment under the policy, it might jeopardize benefits under the policy and look to that, but always put potential tortfeasors on notice, and there is the case which talks about the effect of a release when the tortfeasor has knowledge. Now, auto subrogation is famous for this. Hey, dear tortfeasor carrier, liability carrier, I've got a $5,000 claim. Please send your $5,000 check to me at this address. And you get a check for $2,800 saying, well, you didn't use aftermarket parts, or we think you paid too much, or the bumper didn't need to be replaced, or this MedPay payment didn't need to be paid. And the third-party carrier sends you a check that says payment in full for something less than your full lien, and you endorse and cash the check and then make a demand for the remaining 25%. It can be what's known as accord and satisfaction. It can bar you from recovering the remaining 25%. In order for that to happen, the parties must agree that the amount paid is full satisfaction, and that can be where it's written on the check. You sign this check, you've accepted this in full. Or if there's discussion between the parties. So be careful in what you say in your settlement communications by and between yourself and the third party. But in our favor, there must be unmistakable communication that acceptance is a complete satisfaction. It applies only to unliquidated or disputed claims, and what you do if you get a check for less than what you want, you just return the check. Make a copy, record everything, and return it and say no dice. Now, we all see the cases involving the 2004 Ford F-150 that starts on fire and burns up in a driveway. We hire, hopefully, somebody of some quality to do a cause and origin. And by the way, I like to say there is no such thing as a cause and origin expert. There's an origin expert and there's a cause expert. We usually engage the origin expert, and he points under the hood and says, yeah, the fire started yonder. Be careful, because that's not going to get you to first base. You have to know what the cause of the fire is. And if you can prove that there was a problem with, say, a faulty alternator, the economic loss doctrine, and we have a chart, by the way. We have a chart that talks about this in all 50 states. And by the way, if you go to our website, there are charts on just about everything. Feel free to use them. If you notice anything that needs to be updated or changed, please let us know. You will not hurt our feelings. That's how we keep them current, and they are updated daily, literally daily. But the rule is where a defective product causes damage only to the product itself, you cannot recover in tort, strict liability, or negligence for purely economic damages. What does that mean? You can't recover for the damage to the product itself. 2004 Ford F-150 starts on fire, burns up. It burned itself up. You cannot sue the manufacturer for strict tort product liability to recover back for the damage to the product. Now, if the Ford 150 burns down the house or the garage in which it's in, you can then recover for the damage to the garage. But the economic loss doctrine says you can't recover for the damage to the product. There are exceptions. Damage to the product itself is recoverable in tort if the defect presents an unreasonably if it's unreasonably dangerous to person or property and causes accidental damage to other property. The other property damage we discussed, or not likely in a 2004 Ford here in the year 2017, but if it's a newer vehicle and you have warranty or contract-based statutory remedies, we may be able to step into the shoes. So in those types of cases, always try and get the warranty. You're talking to the insured, by the way, what is the warranty on that claim? You want to see that. It might be a drivetrain warranty, and of course the fire had nothing to do with the drivetrain, so that's not going to help you, but many warranties will allow you to get a replacement of the vehicle depending on the nature of the loss. So express or implied warranties can be pursued, and in some cases like motorhomes where you have a Norcold refrigerator that's installed in there, it can be considered a component part, and if it fails and burns up the motorhome, then you can pursue the manufacturer of the Norcold refrigerator rather than the manufacturer of the motorhome itself. Deductibles. This is one of our most common questions because people feel like they're going to be sued, and companies have been sued. Class action suits by trial lawyers who don't have enough to do because we didn't properly reimburse a deductible. Well, Arizona Administrative Code says that with regard to an automobile insurer's obligation to recover and reimburse all or a portion of the insured's deductible, those are two separate steps, recover and reimburse, and states treat them differently. But Arizona says that we have to, upon the claimant's request, include the first party claimant's deductible, if any, in subrogation demands. So I always include the subrogation deductible rather in the subrogation demand. And then when you make a recovery, your recovery must be shared with the insured on a pro rata basis unless the deductible amount has otherwise been already recovered. So when this happens, there's no deduction for expenses that can be made from the deductible recovery unless an outside attorney is retained to collect such recovery. This is another one of the reasons why I say Arizona is a state to engage subrogation counsel, because you cannot recover a lot of allocated loss adjustment expenses or things that you cannot include those in your pro rata calculation for the deductible unless you have at least engaged an attorney to pursue outside collection. That allocated loss adjustment expense is another issue unto itself. Collateral source rule. It's a common law rule. It essentially says that it prevents a reduction to an award of damages by a jury due to compensation from a collateral source. What's a collateral source? You are a collateral source independent from the defendant. You, the auto insurer, the med pay carrier, the collision payer, health insurance companies, work comp, these are all collateral sources. And injured plaintiff goes and tries a case and gets a $100,000 jury award. That jury award cannot be reduced based on the $25,000 that you've paid in MedPay. And it makes evidence regarding such collateral compensation inadmissible, and there's the case, Norwest Bank. However, there is a statute that says in medical malpractice cases, evidence of collateral compensation is admissible. So the plaintiff may recover the full amount billed by a medical provider, even if the provider accepts a lower amount. This is important when you have MedPay bills and the plaintiff's attorney says, well, I'd like to work with you guys. Can you give me a copy of your bill so I can demand those? Hey, Mr. Trial Lawyer, don't demand what we've paid. Demand what was billed, because it's significantly higher, and the more money in the kitty, the more of our lien we can get back, and the more fair it will be under the statute, which requires that we have to be fair and equitable in agreeing to reduce or compromise our lien, as you recall. So that's significant. I think it's important to recognize that we have contributory negligence and comparative fault issues that play a role in every case. If you're in one of the North Carolina or one of the pure contributory negligence states where 1% will knock you out, you ought to consider those things when making your subrogation decisions. Correspondingly, if you are in a state which has pure comparative fault, and Arizona is one of only 13 states that has this plaintiff-friendly contributory negligence comparative fault paradigm, then the plaintiff can recover even if, that means you're insured, that means you, when you're subrogating in the name of your insured, who is 99% at fault, can recover. But of course, your recovery is reduced by the percentage of fault. So just because you have a 70% at fault insured, there's no reason not to subrogate, provided you don't have corresponding damage on the other side. Obviously, if your insured is 70% at fault and they have an equal amount of damages, you're going to get 30% of your damages and you're going to pay them 70% of their damages, and that's not a win. So this takes a big picture outlook constantly, but you know what I might do? Let's be bold. I'm going to, Jamie's going to freak out. And I can hear her laughing in the other room because she monitors this. I want to go to the website real quick just to show you, for example, this chart and some of the resources that are available. Here's our website. There's the picture of all the handsome lawyers, attractive lawyers. Okay, here's the base. Ask a question. It's important that you guys realize you have this available to you. If you click on Ask a Question, you then have a form with a couple of basic informational questions, and that's to weed out Autobots and things like that. And then you can type in your question, how tall is Gary? And you click Submit, and that question comes to us. You normally get an answer within 1 hour. It can be in any jurisdiction, Canada, Mexico, any of the 50 states, South Africa. We have local counsel around the world, and we have a procedure and a contract in place. We get answers to your questions. Why do we do that? Obviously, we want your business, but even more importantly, we want subrogation to be informed, because the more informed we are, the better the industry itself evolves. And we have had problems in our industry and bad decisions because we have sat on our thumbs and we didn't have answers to the questions. There's a referral file feature here. This is the easiest way in the world to refer us a matter. You fill this information out, go to the next form. You can upload securely your entire file, send it to us. It gets reviewed, it gets accepted. You get an automated date stamped timed receipt showing when we got it. Here's subrogation charts. This is what I wanted to refer to you to. MedPay PIP in all 50 states. Okay, we're talking about Arizona, but if you go to the chart, you can see here, and many of you make use of this already, but I've had a lot of questions like, do you have a chart on MedPay and PIP? And the answer is yes, and here it is. It goes through the basics of MedPay and PIP, and then we get to each state. And here's Arizona right here. And it talks about MedPay and PIP. It gives you quick answers. Talks about statute of limitations. It's a great resource. There's other charts, including economic loss doctrine, all 50 states, dog bite spoliation laws, subrogation of criminal restitution, recovery of sales tax after vehicle total loss. Okay, we're not talking about that in Arizona, but let's look it up. You have sales, you have a total loss, and the insured has to buy a new vehicle. So we go to Arizona and we look here and we see that on first-party claims, it tells you what the policy has to say. And on third-party claims, which is what you're interested in, they have to follow the same rules as first-party insurers. So you can make an argument for recovery of sales tax in that instance. And of course, there's all of these different charts that you can look to, anti-indemnity statutes, Wisconsin are made whole, automobile total loss thresholds. What the heck is that? This is one of our most visible charts, and it's used by the industry a lot. It talks about all of the the good stuff in here. I'm supposed to give you real quick the trivia question, and remember, this is Jamie. Can you bring me that trivia question? I'm sorry. I thought I had it right here. Oh, wait, is this it? No, Jamie, can you bring that to me? So anyway, these are the charts. They're oh, here it is. Here it is. Okay, here's the trivia question. And again, once I give you the question, provide your answer through the question pane on your dashboard. The first one to answer correctly wins an MWO book of your choice, and we will reveal the winner at the end of the webinar. Jamie, with our office, will contact the winner via email after the webinar to find out which book you want. Here's the trivia question. Which common English word changes its pronunciation when the first letter is capitalized? Which common law English word changes its pronunciation when the first letter is capitalized? All right, so let's go back to the CE code. Oh yeah, the code word. The code word that everybody has to submit is, and this is the first time we've had to do this, so you'll have to bear with me, MWL knows Subro. MWL, Matthiesen, Wickert, Lehrer. MWL knows, in other words, we know, knows Subro. Okay, slide 23. This is what I get for not listening to Jamie. My fault. So when we're talking about things like these kinds of questions, you can go to the website and you can look these things up. I apologize, I'll get there. Sudden emergency doctrine is something I wanted to discuss, and we will get to that chart as soon as my slow-moving screen gets us there. Collateral source rule. Here's the sudden emergency doctrine. I want to mention this because it's interesting in Arizona. An emergency situation arises unexpectedly. It's not proximately caused by the defendant. The defendant must act as an ordinary prudent person under the same circumstances. That's important. An example, driver A is driving his vehicle and all of a sudden a tree falls into the roadway in front of him. Driver A swerves to miss the tree but crosses the center line and hits driver B. He has a sudden emergency defense. It doesn't mean he's not responsible, but it means that he has the opportunity to prove that anybody faced with that tree would have done what he would. And I would argue, well, you swerve to the right and go into the ditch, not into the center lane. For example, a defendant driving 75 miles an hour in fog suddenly comes across a traffic backup and rear-ends somebody. Sudden emergency? No, not so much, because it was proximately caused by the party himself. It was foreseeable, and so that's important. Seatbelt defense. I will just say that the defendant can show that the plaintiff used a seatbelt and that failed to use a seatbelt rather, and that non-use of the seatbelt was unreasonable. Then the jury can decrease the injuries and damages. So seatbelt issues are important. Don't forget to look to those when you are subrogating. Bailor, bailment, the bailor is the owner of property. The bailee is somebody who the property is given to. You go to a restaurant, you give the coat to the coat check lady. You're the bailor. You own the coat. You gave it to the bailee. The bailee is the restaurant. The bailee holds that property in trust for you. So there's delivery, there's acceptance, there's an implied contract, there's understanding the property will be returned. When you have auto cases, such as, well, the car was left with the repair shop, and the repair shop opened up one day, and lo and behold, the car was stolen. Well, they're automatically liable. In other words, the presumption is that they were negligent unless they can prove they weren't negligent. So the burden of proof shifts. And just you can't limit liability to a small amount in a bailment receipt. You can't put a sign up that says not responsible for lost articles. In order to avoid it, you have to have the bailor's conduct. In other words, you, the property owner, must indicate an agreement to the terms and conditions of limitation contained in a receipt. In an invoice, it has to be conspicuous on the back of the invoice. Parking lot situations, dealerships, repair shops, all great examples. Negligent entrustment. We know negligent entrustment. I'll just quickly say about this that if you, if someone lends their vehicle to an unqualified driver and that driver's negligence causes an accident, you can sue the owner. Why do I always include negligent entrustment claims? Because that gets me into the driving record of the defendant, which would otherwise be irrelevant and not admissible. But now that I'm trying to prove that the owner should have known that this guy was careless, I'm entitled to look at the driving record. But negligent entrustment can also be loaning an unfit vehicle. The brakes aren't working. I remember back when I was in law school and I had no money. I had a vehicle that was just no brakes at all, and I sold it for $200. And some poor guy came to pick it up, and I didn't even tell him it didn't have brakes, and he drove away. And I'm just thinking, wow, I don't even know how he stopped. I could have been held liable because I negligently entrusted that vehicle to him. He could have been Mario Andretti, but the car wasn't worth it was garbage. So negligent entrustment claim could have stood. Guest statutes, I'll just say that there are no guest statutes and leave it at that in Arizona. But Arizona has the family purpose doctrine. So even if you have somebody who is uninsured, there's a vicarious liability rule in Arizona that holds that the owner of a family, of a vehicle liable, the rule holds the owner of a vehicle liable for damages to others while a member of the family is driving. Arizona recognizes the family purpose doctrine, and essentially it says vehicle furnished by the head of a family to the member of a family. What's the head of a family? If I told my wife I was the head of the family, I wouldn't be able to go home tonight. But these are issues that can be negotiated, but this is a recognized doctrine. If the car is used with consent, then the owner of the vehicle is liable automatically. Sponsorship liability under the driver's license law, just remember that there's laws that it doesn't impute negligence of a minor to the parent if minimum limits are maintained, but the sponsor is liable for the acts up to the limits of liability. One other thing I want to mention, if you have a multiple claimant situation, a car pileup, or several other people, then you have a small subrogation lien, and there are many larger claims. Unfortunately, Arizona is a first come first serve. Interpleader is recommended on the part of the tortfeasor, but he can settle with the tortfeasor can settle with one or any of you. So first in time, get in there right away and make your claim. They don't care who they pay it to. They're just going to make people go away and make them be quiet. Statute of limitations, I'll leave those there for you. You have them in the materials. Here's the offer of judgment I mentioned. Remember those tips and techniques that we can use to make small claims more, make the other side more eager to settle those. If at least 30 days before trial you make a settlement offer and it's not accepted, you can recover post-offer litigation costs, reasonable expert fees, and you can double the tax costs, the taxable costs. So what I do is you have a $5,000 claim, demand $4,900, and set forth this offer of judgment. Say, you don't pay my $4,900, you're going to owe a lot more than $5,000 if I get a $5,000 judgment. So that's the seminar. I do apologize. You know I'm a stickler for getting people out in time, and I do apologize for being 7 minutes over. The winner of the trivia question is Diane Winslow. Congratulations. And the answer is, of course, the word polish. And when you capitalize the word polish, as in polish your car, you become Polish. So that's essentially the webinar. This concludes the entire auto subrogation series. We thank you for all your participation. I have a couple of questions here that I can get to, and I'm going to print off those questions. While I'm getting this printer going, getting the questions printed off, I will tell you again that the next webinar is going to be on the 10 mistakes that insurance companies keep making. And you're going to enjoy that one. I presented it at CLM, and I presented it in Chicago and at the Executive Summit Conference in Connecticut earlier this year. All right, questions, a couple of quick questions. Robert in Marietta asks, how are loss of use damages in auto property subrogation cases normally proved up? Robert, there's a case called Home Indemnity versus Bush in Arizona, and it's to be noted that in that case the parties stipulated, I mentioned this earlier at trial, that a reasonable rental value would have been $12 per day and 6 cents per mile. That's easy to prove up and should be stipulated to. Bush, in that case, testified that he could reasonably estimate the number of days he was deprived of the use of his vehicle for hunting expeditions to be slightly over 200 days. There was a business involved in that the total mileage would have been approximately 10,000 miles. And the Supreme Court allowed it, but they refused to give an instruction that said something to the effect that you may find as an element of damages that the plaintiff is entitled to the loss of use of plaintiff's automobile for the time plaintiff was deprived of possession of said automobile. So the question as to how to phrase that to a jury is up in the air, but essentially prove up the number of days without the car, the reasonable rental value, and if there's lost profits involved. I don't know of a case online that's accurate and on point for that, but there may be one. Melody in Sacramento asks, what about recovery of allocated loss adjustment expenses in auto property subrogation claims? Wow, that is one of the best questions I think I've ever gotten during a webinar, and I didn't talk about it. We mentioned, I think, briefly allocated loss adjustment expenses vis-a-vis the deductible reimbursement administrative code section. Can you deduct those ALAE costs from the deductible if an attorney is retained? But I think what you're asking, Melody, is property insurers could simplify their business practices and lower their overhead by simply paying any property damage claim that came along. Paying all claims, expenses, consequential damages, but such a practice obviously would lead to bankruptcy. And I think that the industry has a claims adjusting process for a good reason. It's important to determine things like coverage, legal liability. It's important to settle claims fairly, investigate third-party potential. So when ALAE, there's actually two types of loss adjustment expenses, allocated and unallocated. There is no law in Arizona regarding this, by the way. So as to Arizona, I don't have an answer for you, but there is an answer in many states. And there's an article, you remember when I went through the tour of the website, one of those charts, there is an article there on recovery of loss adjustment expenses, I believe. So allocated loss adjustment expenses are the expenses incurred for a specific settlement. For example, you hire an engineer, you hire to look at a vehicle, or you get an appraiser, and there's a cost associated with that. And then unallocated are expenses incurred by you, the carrier, for routine expenses of claims departments like salaries and maintenance. You can't subrogate for those, but in many states, and the law is changing, where they realize the value of these things and that it keeps down the claim, and it's important and helps hold down premiums, that those kind of ALAE claims can be recovered. I don't have any specific information on states that can and can't, but that's just a brief answer. But that's a great question, and one that I would direct you to the website, to the resources that I pointed out. There's a couple other questions coming in. I will get to those. In everything that's asked, I will answer. And again, it doesn't have to be just about Arizona. Thank you so much for your attendance. We appreciate it. Please consider us for the handling of your auto subrogation, MedPay, PIP, no-fault collision, property, comprehensive losses. We'd be happy to and honored to represent you. Thank you very much, and enjoy the rest of your day.